To the High Court in Bloemfontein. That's where we are still taking in some of what is taking place there. The case against convicted murderer Thabo Bester and his 8 co-accused, including Dr. Nandipha Magudumana and her father, who had a short exchange a short while ago. That case is back in court today. It's for a pre-trial hearing. There's been a short adjournment after what seems to have been a health incident involving one of the accused, who quite literally belted out in the middle of the session just a few moments ago, which led to this particular adjournment. And what we've been able to witness during this break is interaction, I should say, between the accused, including a short exchange between Nandipha Magudumana and Thabo Bester himself. You might remember she had tried to declare her arrest in Tanzania unlawful, and part of what she cited at the time is that she was forced to go to that country against her will by Thabo Bester, which some people, of course, suggested had meant there'd been a breakdown in their own relationship. Of course, all of this dates back to May of 2022. That's when Thabo Bester allegedly faked his own death in prison and used the body of another person as a decoy. All of this, of course, has been unraveled throughout the course of investigations after he was spotted. I think it was at a shopping mall in Johannesburg. I stand to be corrected on that. And so much has happened since then. The presiding officer is now back inside the courtroom. Let's listen in.
I hear that your client's condition is rather serious.
Indeed, so, my lady. Miss Bester assisted. An ambulance is on its way. It seems as if the ambulance is here at court, and a family member accompanied the accused down through with security to the back gate of the court so that the ambulance can come and pick him up.
We have resolved these issues.
Yes.
So would you have any objection if the proceedings continue in his absence?
No.
I do not foresee any prejudice.
Neither do I, my lady. We can continue.
Thank you. So we can proceed.
Thank you.
Thank you.
As the court, please, my lady.
Thank you, sir.
Apologies for interruption.
No, not at all.
I had made a request in the morning, considering the fact that accused number 7 is sitting at the back and it's very far. So sometimes he would want to pass instructions. So I had approached the prosecutor asking that he be brought closer so that there will be easy facilitation in passing of instruction. So I see one of the accused has been excused, so there is enough space if the court is amenable to just have him closer.
I would prefer that they sit in the sequence as they are sitting. He can just put his hand up, and if he needs to give you any instructions, I will allow you to go closer to him.
As the court pleases.
Good. That is also better for security.
Yes, as long as your ladyship can see his hand, because
I can see his hand, and I'll ask my registrar to also keep an eye on him, that if he raises his hand, that we will give him the necessary attention.
As the court pleases.
Thank you. Mr. Bester, you heard what we just said?
Yes.
If you want to give instructions to your counsel, you are welcome to just put up your hands, draw our attention, and we will ask your counsel to go to you to take instructions. Thank you. Thank you. Thank you. So we left off with accused number 8, Mr. Zanda Boniface Moyo. Mr. Moyo, thank you. Who is his legal representative? You, Ms. Kruger?
My lady, yes. During the adjournment, it was legal aid, my lady. So Mr. Motlang already withdrew, so legal aid is officially, if I could put it like that, on record then for Mr. Moyo.
And if you say legal aid is officially on record, is it going to be you that represent him, or is somebody else going to be appointed?
My lady, at this stage it's not going to be me. He is linked to one of the practitioners that we already appointed, my lady.
Good. So that has been resolved.
Yes,
There's no necessity for a jury care or other processes that has to be followed.
Not with regards to Mr. Moyo, no.
Thank you. Mr. Moyo, are you then so satisfied that Legal Aid South Africa will represent you?
Okay, uxolile tata ukuthi-ke umelwa ummeli ovela ku-legal aid njengoba bavumile isicelo sakho babuza umelwa nguye ummeli ovela ku-legal aid. I confirm same one.
Thank you for that, Mr. Moyo. Of course, also, just as I indicated to the previous accused, you must make sure that you stay in contact with your legal representative. It's your responsibility to ensure that your legal representative is properly instructed and that you are available for consultations at all times. You understand that? Ms. Kruger indicated to me that it might not be necessarily herself that's going to conduct your case or represent you. So you must make sure that you find out who your legal representative is, how you can contact that legal representative, and how you must go about arranging the consultations or be present in the consultations.
So, Ma'am Kruger, I want to we are so
Thank you, Mr. Moyo. Thank you. This brings us to accused number 9, Mr. Jill Lechare Mageta. Thank you.
May I please the court, my lady, confirm my appearance on behalf of Mr. Mageta, my lady.
Thank you. Thank you, Mr. Mageta. Are you satisfied with the fact that your counsel will be appointed from Legal Aid South Africa? Thank you. Thank you. You also heard what I said to the previous accused. It's your responsibility to make contact with your legal representative and to ensure that you are available for consultations and that your legal representative is properly instructed. Thank you. Thank you, Mr. Mageta. Thank you. Now that we have resolved the issues of legal representation, you would have noted that I called this case management hearing due to some issues that has not been resolved during the appearance on the 13th of January 2025. I refer to paragraph 4.1 of the notice that I sent out, and that is the issue in regard to paragraph 2 of the order dated 13 January 2025. And that is the issue of the 7th accused to file his reply in terms of section 212B before the 28th of February. Mr. Mohela, that issue is also pending, am I right? It is before my brother Daffy.
Not pending before your brother Judge Dafu, my lady. He has already determined the leave to appeal.
Yes.
But what is pending is the further appeals. But the accused is unable to exercise such a right because on the 13th of Jan 2025 there was an order, and we asked for reasons thereof, and then we filed an application for leave to appeal against that order, specifically the completion of 212B, and we're under the impression that on the day of the hearing, on the 13th of Jan, the judgment was given extempore, the reasons thereof for that particular order. So when the leave to appeal was had, we had transcribed the record of the proceedings, and we asked that the signature of the court be appended and it be a court judgment or the reasons of the order. But on the day of the hearing of the leave to appeal, that had not been done in terms of the signing of the reasons for judgment. So the first thing that we impressed upon the court is that we were of the view that the matter is premature, in a sense, or it's not ripe for hearing in the absence of the reasons being signed by the court. And then we were assured that it will be done thereafter, the hearing itself. Then we proceeded on that strength. Then the leave to appeal was then dismissed. So we then asked that in light of the fact that we have the leave to appeal judgment, we sought also the judgment for the order granted on the 13th of January, and we had not received. In fact, what we received is that that order was given without reasons. So, and we were advised that if we are not satisfied with that, we can take it to the JP. So my instructing attorney had drafted the draft letter to be addressed to the JP, and my instruction is that it's going to be sent immediately after this court for us to seek reasons, and so that we can exercise the further right that the accused might have, if so given such an instruction. But that matter, I just wanted to address that it's not pending before Judge Dafu, in the sense that he has already pronounced on the application for leave to appeal. But the short answer is that that statement itself has not been completed because of that process.
I saw a judgment of my brother Dafu on the 2112 issue.
That's a leave to appeal.
Is that the leave to appeal
Yes.
judgment?
Yes, that's a reason for leave to appeal. I think it's uploaded on Safli.
Yes.
Yes, yeah.
Yes, I saw that. So your gripe is with the fact that you didn't receive reasons on the judgment, I quote, on the original judgment.
Yes.
So you cannot now take the matter further to the SCA.
Yes, that's an impediment, yes.
Yes, yes. So this is another pending matter that may cause us not to start on the 21st of January.
Not really. That aspect, my lady, it cannot stop the trial from starting. Remember, if everything is resolved in our favor in respect of Section 35, or if your lady can grant an interim arrangement for consultation, that issue can be resolved, the 212B statement, because the 212B statement, it's blocked by the pending application itself. Because once we consult fully, then we are able to participate meaningfully. Because we say that this is not a tick box exercise. We need to take instructions so that we can address certain questions that are posed in that questionnaire.
So if the consultation issue has been resolved, you will be able to take proper instructions from your client to compile a reply to the 212 notice and then supply it to the state and the court.
Yes, that was our contention, yes.
Yes, so there is not pending litigation on that.
No, so there are two answers.
That's what worries me.
Firstly, it won't the pending application. If by tomorrow we have all the consultation regime, the trial can proceed despite the pending application in 212B, because the pending 212B statement, it is in terms of the leave to appeal, we are saying that it has set a dangerous precedent. That issue can be sorted absent the continuation of the trial. The trial can continue simultaneously with that application. Unlike Section 35, Section 35 needs to be resolved for the trial to proceed according to how we view it. But Section 212B can proceed the further appeals, but it won't stop the trial as long as there's been consultation and we are ready for a trial.
I'm concerned about that because non-compliance with Section 212B might cause some calamity in the trial. But let me hear from Ms. Bester on your submissions to the court, because then the plea proceedings and what happens afterwards might be affected, and that might cause the trial to be suspended at that stage. Or, yes, but let me hear from Ms. Bester what she says on that.
Oh, if there's something, I'll have an opportunity to
You will
answer.
reply. Thank you. You will have the last say. Thank you, Ms. Bester.
I see the application and what you want to do is quite simple. If they're able to have proper consultations, they were able to submit their D1Ds. So it's my submission.
If they want to.
If they want to, remember.
I know. Yes.
So you have to see these admissions.
Yes.
If they don't reply on that, whether they're going to prefer not to reply on that, that's another issue. But I think this so-called pending application regarding the 212 it is really a fruitless exercise. And everything is going to be finalised, could be finalised, as soon as the decision is made regarding the application that was legally applicable at Judge
Mbele. Thank you. Thank you. Thank you. Anything to add, sir?
No.
She actually agrees with you.
Yes.
Thank you. Thank you. Then paragraph 3 of the order dated 13 January 2025. All the accused persons' legal representatives shall ensure that they, by appointment with Senior State Advocate Bester on or before 31 January 2025, download the information held by the state in digital form by making use of their own memory sticks or similar devices. Has this been resolved by everybody, Mr. Mutlaung?
As a court is mandated, to a large extent this was complied with, except that at some point I was in contact with my learned friend from the state with regards to us just ensuring that that what they have is what we also have. So there is that process that is underway, which would not be an impediment in us proceeding further.
As long as you give me that undertaking, that it will not cause any delay in the trial?
Indeed,
thank you. Thank you. From your side, Mr. Reineke?
I've served in my notice my reply that I've received and my things are all up to date that I've got from Ms. Bester.
Thank you, Ms. Kruger.
Confirm so, my lady. Thank you.
Thank you, Mr. Mohela.
The answer obviously flows from accused, Mr. Bloem. We have made arrangement because he's in Bloemfontein that when he goes there with the USB, he also dissociates that information for accused number 7. And all these arrangements are in line with the current status.
Good. But you, in the end, the buck stops with you.
Yes.
You must make sure
Yes.
that you have all the information.
Yes.
You can't later come and say Mr. Mutong made a mistake. He didn't get all the information and blame him for that.
No, we can't blame that. It's just like a messenger, but we can't blame him for that.
We won't kill the messenger, Mr. Mutong.
I'm sorry.
We will not kill the messenger.
I'm relieved.
Yes. Thank you. Thank you. Thank you. Then paragraph 4 of the order. All the accused persons, legal representatives, shall on or before the 31st of January 2025 and at their own costs obtain hard copies of the extra statements obtained by Advocate Bester. Mr. Mutlaung?
That's the same process.
Same. Is it still in process or has that been completed?
It's in process in terms of us having to ensure that what the state has is exactly the same as what we have. So it's more of us having to reconcile what we have. But we have the necessary docket from the state, and what we have, my leader, must just take the court into confidence that what we have is enough to ensure that we are ready and for trial.
Thank you for that undertaking. It's indeed helpful. Thank you, Mr. Reineke.
I can confirm it as such, Madam.
Ms. Kruger?
Confirm, my lady.
Thank you.
Accused number 7, same arrangement as order 3.
Thank you. Thank you, Mr. Moela.
The last part of this statement, I didn't give it to Mr. Mutong, so they don't have it. So I must wait for you to get that in order to do. And I didn't receive any request. I provided them with the amount on the 14th of January, but I didn't receive it. In fact, I didn't use Mr. Mutong's job at all. You got it, I don't know from you. But if there's something missing, I'm not responsible for that.
But he indicated that he is going to consult with you and to just, as he say, reconcile the documents and make sure that he has everything. So I've got an undertaking from him. Thank you. Thank you. Then in regard to paragraph 5, that is the issue of Mr. Sekeleni's legal representative. I can just emphasize here that the order, Mr. Sekeleni, was that it is recorded that the fourth accused, Mr. Sekeleni's legal representative, has withdrawn and that Legal Aid South Africa has been approached for legal aid. But as indicated by Ms. Kruger, who appeared on his behalf, the application for legal aid, but that she will assist accused 4 in his appeal procedure forthwith. She did assist you. You did not come to the table. Ensure that you keep in contact with Ms. Kruger and that you supply her with the necessary information and documents so that the appeal can be finalized on this issue. Thank you very much, Mr. Sekeleni. Okay, let me introduce you formally so that you know. Ms. Kruger, can you just stand up? This is Ms. Kruger. Before you go away today, Mr. Sekeleni, make sure that you have her contact details.
Well, lady, I can confirm I have been in contact with Mr. Sekeleni. I have his telephone number, I have his son's telephone number, I have his email address, and we've also arranged that he must come to the office now after the court appearance, my lady. So he will be coming to the office. Thank you, my lady.
Mr. Sekeleni, just again to emphasize, if you do not participate, if you do not do your due diligence to obtain legal representation, the court may, in terms of section 342A, in the interest of the administration of justice, order that the matter proceed with or without a legal representative for you. So be very careful that you attend to Mrs. Kruger or Ms. Kruger's office.
We are advised, who are the about advisors. I put on the other OT. So we are to have a Thabo Bester.
Any questions from your side, Mr. Sekeleni? Nothing. Thank you. Thank you. Then. Thank you, Mr. Bester. Who's accused number 8? Accused number 8, whose client is that?
That's legal. Sorry, my lady, that's legal aid, my
He's
lady.
raising his hand. Maybe you can just get instructions from him.
May I approach?
Ms. Kruger, you may approach.
Thank you, my lady.
Thank you.
Thank you, my lady. It's just with regards to consultation. Thank you, my
Thank
lady.
you. Thank you. It's good that that seed has been planted now. Thank you.
Thank you, my lady.
Thank you. Then the last issue, and I think that is also a crucial issue, Mr. Mtlaong, it goes to your client. Any outstanding litigation or issue that might affect commencement of the trial on 21 July 2025. There is the extradition judgment in the SCA.
Indeed, my lady, it's actually no longer in the SCA. Judgment was issued, it was delivered, and the matter is now before Constitutional Court. We have referred the matter in terms of Rule 19 of the Constitutional Court rules for leave to appeal the majority judgment which was delivered in the SCA. So indeed, this is a pending matter.
And what effect will that have on the case itself? It goes to extradition and jurisdiction.
It goes to jurisdiction, my lady.
Yes.
And it directly has an impact on the matter.
Yes, yes.
Indeed.
So, do you foresee that the matter will be able to proceed? We will be able to proceed with the matter on the 21st of July?
My lady, it's unlikely. It's unlikely because the issues that will be raised on the 21st, it's issues that are before the Constitutional Court.
Yes.
Yes. So that in itself would impede on the matter or impact on the matter proceeding on the 21st of July.
Yes. So it will go to section 106 of the Criminal
Indeed,
Procedure Act
indeed,
and the jurisdiction issue.
Indeed, my lady, that's
And
the
if that
direction.
is resolved in the Constitutional Court, then the matter can proceed
Indeed, my lady.
without any impediment. Thank you for that, Mr.
Thank you,
Mtlaong.
my lady.
Thank you. Then, Ms. Bester, you had some issues that you filed with your counterparts. If we can address those, I think we have addressed some of them. Oh, that's good.
Just the financial assessment, there are some financial instructions already. Did you see the matter?
Yes, I think the accused that has legal representation on private mandate, Mr. Mtlaong, Mr. Mohela, you are satisfied that you will be able to see this matter through until the end.
Indeed, my lady.
Thank you. That's your undertaking and commitment. Same for you, Mr. Mohela?
Yeah, that is true, my lady, but with a caveat. With just a caveat. In that I know that the trial has been estimated to run for 6 months on estimation, but depending on the consultation itself, we can fully confirm. But for now, we've been assured but not placed.
In funds?
Yes, for the trial itself. What we've been, it's been ad hoc invoicing from now, but for the trial itself, it will be dependent on the fullness of the consultation.
We can't continue on that premises. You will have to give the court an undertaking that you will see the trial out until the end. Remember, there is case law. The debt that happens between you and your client is between you and your client. It's nothing to do with the court. You must take the instruction or not take the instruction.
May I please approach my lady?
Yes.
Thank you, my lady. I just wanted to clear that particular aspect, and then I'm indebted to you, lady, for asking me to clarify it. I can confirm that I will see the trial through.
Thank you very much for that. That's a huge undertaking. Thank you. Thank you very much for that commitment, Mr. Mahela.
My lady, if there's nothing that, because I was just waiting for everything to be addressed so that I can make one request, but I'm in the court's hand. If everything is sorted, then to be given an opportunity.
Good. So I think we've dealt with all the issues. As soon as Advocate Bester and Advocate Mutlarong is done with their consultations, we can proceed. I know it's necessary to consult, very necessary. So I think, Ms. Bester, anything else from your side?
That was what's all our consultation about, and that was the 200 visa accused number 8. I don't have a copy of that. I went through the court's file with the help of the secretary. We can't find a copy of that. Mr. Mutlarong showed me now on his tablet that it was indeed written. So now I don't know. If he didn't file it, can he still file it? Because he's no longer representing him. So
Accused number 8. So you will have to consult with the legal representative of accused number 8. So I'm sure that between them they will resolve the issue.
and maybe we can sit with Brian must be filed.
Good, good. I'll get to that just now. I'm sure that's easy to resolve, Mr. Mutlarong.
Indeed, my lady.
Indeed so, my lady, yes.
Thank you. Accused 3, sir, your hand is up. Who's his legal representative?
May I just approach accused number 3?
Thank you.
Thank you, my lady.
Thank you. Thank you, Mr. Reineke.
Thank you for the indulgence, my lady. Ms. Bester and I had a short and sweet discussion. Accused number 3 has moved house. He used to sign as part of his bail conditions at Kagisanong police station. By agreement between the parties, I'll ask the court to amend the order that he signs at exactly the same dates and times per week as he has to sign, but just at the Mangaung police station and no longer at Kagisanong.
Thank you.
Thank you.
Can regard the order as being so amended,
Thank you.
but I will do a formal order on that. Thank you. So where was I? Ms. Bester, you indicated you have nothing further.
I don't know what to say any further, my lady, because it appears that you're not going to receive anything first.
Absolutely, and it's a blessing that we did this inquiry or this hearing today. This might not be the last one before we start in the end. I'm going to keep doing case management on this matter.
If I have a suggestion, the second matter down for the last week, the ending days, I think after November, first week in this year.
Yes.
And they have a whole first in 2026. That we will keep
2026.
that 2026. But we will keep that dates and maybe have again postpone this matter to a provisional time to see what is going to happen in the constitutional matter as well as the application with accused number 7. Just regarding the constitutional matter, the patient aspect, when they approached the constitutional court about the patient, that is our case, and the respondent is going to file their lease today. So if they grant permission, it's going to be quite a longer process. If not, we can finalize it.
Good. But I will keep on doing case management on this case. Mr. McLean, nothing to add?
Nothing from me, my lady.
Mr.
Nothing new, thank you, my lady.
Ms. Kruger?
Nothing, thank you, my lady.
Thank you. You wanted to address the court, sir?
As the court please, my lady, it's not nothing to add, but it's just a request. Two requests because the accused is before your ladyship. The first one is simply to ask for an interim measure, if your ladyship is amenable, for consultation so that we can be somewhere when we come back for the second case management.
I can't do that, sir. That is, first of all, I'm of the view that it is part of the executive's it's the executive's priority. It lies within the realm of the executive. Secondly, you have this litigation pending. So I'm not going to make an order in contradiction to the litigation that's pending at the moment. I cannot do that.
I won't take this matter further, my lady. I just wanted it interim. But if
You've made the application, you've served your client. Thank you.
Yes.
Thank you.
The second aspect, my lady, we normally take this opportunity after court to consult with the accused. That is the request that we are making for today.
Again?
Yes.
Completely outside of my realm. I cannot order the correctional services people as to how they conduct their processes. So I'm not going to make that order. There is the issue of security. There's a lot of factors to take into account. So I am not going to make an order in that regard.
As the court, please,
thank you. You can always go and consult at the prison if necessary.
As the court, please.
And I do not know if we really have the facilities here to accommodate that.
We do, my lady, because I don't want to speak post the pronunciation, my lady, because obviously that's incompetent. But mostly the accused is brought to court in the morning until the end of the court day. So they take advantage that he's leaving at 11, but it's not the executive arrangement. It's just how the proceedings would have unfolded. So normally we would say that it's actually an issue of courtesy, that can we just see him for 2 hours, and not because of executive arrangement. He was in court. He was going to, if we were going to argue for the entire day, we will be released probably at 4. So that means the court can still keep him until 4 because it's before the court. But I don't want to
I'm not
speak
keeping
the
him
judgment.
until 4. That will be very,
We can take any time.
But of course you can build relations with the personnel of the Department of Correctional Services, and they can assist you. Mr. Do you have something to add on that?
Yes, my lady. One of the colonels of the Correctional Services are in court, and we had a discussion, and he will do it. He will do it, but he will only allow 1 hour.
Good. So there you've built the relationship, so please continue to do that and see what can be done. Thank you for that request. Then it cannot be. Good. Then that leaves us with the accused. I just want to quickly confirm with the accused whether they are all satisfied or whether they have anything to add. Accused number 1, Ms. Magudumana, you're satisfied. Thank you. Accused number 2 is not here. Accused number 3, sir? I am satisfied. You're satisfied. 4, Mr. Sekeleni? Thank you. Accused number 5, Mr. Masukela?
Charges were
He was withdrawn. Accused number 6, Theo Franz Mahotsa, sir.
I'm satisfied.
Thank you. Accused number 7, Mr. Bester.
Your Honor, I just want to state that my instructions to my legal teams to try and process this consultation issues or whatever issues we need to prepare for trial as soon as possible. Because I do also feel that the trial is affecting me in other ways. So I would like to say to the court that my full commitment is to try and finish this trial as soon as possible.
I so appreciate that insight and that commitment, Mr. Bester, because it's in the interest of the administration of justice and everybody present that we expedite the matter. Thank you for that commitment. It is appreciated. Thank you. Accused number 8, Mr. Moyo.
No, I'm satisfied.
Mr. Mageta, last but not least. Satisfied, thank you. So what I would want from you is to draft me an order as to the postponements, the arrangements you want for us to make in the order, the filing of the 2112B statements, everything that you want to be in an order, draft it for me, and then just submit it to me in chambers. I will just go through it, and then I will make the draft order then an order of court if it is in order.
Already set the date?
Yes, the date is then the date that was in the order of the 13th of January, and that was the date of, let me just see where it is. Can you remember? It is the 10th of November until 5 December. It's in the order of the 13th of January, and as well as the first term of 2026.
My proposal is, can you postpone this now? It's still to the 21st.
For?
Further case management. Because then hopefully the appeal procedure will be sorted out, and then we will know if there is indication, most definitely about the constitutional or maybe really not going to be in time. And hopefully regarding the
that's not going to happen.
The last one is not going to.
Yes, that's not going to fly. But good try, Ms. Bester. Very positive. So maybe between all the council, they can decide on the next case management hearing a date, so that we don't have to have emails to and fro. And you have your diaries, decide on it now, and then include it in the draft order for us. And then I can also know how to arrange my diary for the court terms that are to follow. So, just now, am I going to make that order in court, or will it be a draft order made in chambers? I prefer in court. How long will it take you?
Well, my time is here, Mr. Nandipha.
It is now 11:31.
Right, these are live visuals we're beaming to you from the High Court sitting in Bloemfontein. The case involving convicted murderer and rapist Thabo Bester and 8 co-accused has been sitting for quite some time in the form of a pre-trial hearing. There is now an adjournment taking place for the defense lawyers to all agree on a date for trial to finally begin. Something suggests to me, of course, that we're still a long way from there, given some of the objections that were raised about setting a trial date now. At the heart of it, really, is just some of the interlocutory applications that have been made, as well as still issues to do with the time that the accused have to consult with their lawyers. The accused, including Thabo Bester, who you can see there on your screen, mentioning a short while ago that this case has affected him in many ways, and in fact, he is committed to seeing it through. A sentiment that has been most welcomed by the presiding officer, who's added that it's certainly in the interest of justice that the case does move on expeditiously, especially when you consider that the crime itself took place in May of 2022, so more than 3 years later. The trial is yet to begin. We'll listen into the resumption of this case as soon as it does get back into session, where we're expecting a trial date to be announced.